Welcome to Chapter 3, the legal context. This session discusses the legal climate that governs what we can do and how we can do it related to hiring activities. For those of you who thought you could hire who you want for whatever reason you want, surprise, surprise, you can't. Some of the laws, regulations, and rulings detail how much you must pay employees, minimum wage laws, overtime, etc. Some detail who can work and when you can work those people, such as child labor laws, and still others cover procedural issues related to hiring. In this chapter and in this class, we will primarily deal with federal laws and ignore state and local statutes. All the state and local statutes are very different. However, you should be aware of those lower level restrictions and become familiar with them depending on where you work geographically. But the laws we discuss here will primarily deal with the D word. Yes, discrimination. Yes, as I've heard from many managers in various companies, past and present, the laws protecting against discrimination have tied management's hands. They have interfered with management's ability to make decisions that are good for the organization, and they have forced the hiring of unqualified employees or employees that are not the best. Those same laws have prevented management from promoting the best or rewarding the best employees. That's pretty much BS, to put it bluntly. So, what can we do and what can't we do? Well, we know we can't discriminate against people, right? Wrong. You can discriminate. It's legal. Not only is it legal, it is quite necessary and proper. So the real question is not can we discriminate? Clearly we can, but when and how can we discriminate? And for the most part, that is what we will discuss in this session. How can we make our employment decisions in a legal manner and still meet the needs of our business? It's not as hard as it sounds, and it's not as hard as many managers would lead you to believe. But compliance with the legal issues is a business necessity, and straying from the legal path has severe consequences to individuals and to organizations. One of the complications of straying from the legal path is that the path is ever changing. It is not a straight line, and many of the twists and turns are marked with significant fog. But there are some basic guidelines that we can count on that help us navigate successfully. We will also discuss where these restrictions to discrimination come from. You're probably thinking they come from Congress and the law. Once again, not necessarily true. Some of the origins are unclear, obscure, and sometimes conflicting. I'll provide some real-world examples and experiences of how to maintain compliance with these pervasive laws and a discussion of how such laws should never prevent an organization from doing what is right if it is done in the right way. In other words, laws don't impede our drive towards success. Lack of understanding of the laws is a greater impediment. Take some time to nail down these concepts and understand my examples. You can be sure that you will see these laws in the future chapters, but more importantly, they will impact your decisions and your chances for success in your career. So let's dive into differentiating between good and legal discrimination and bad or illegal discrimination. Let's look at the differences, origins, challenges, and maps to success. Now, I'm sure everyone has heard of the Equal Employment Opportunity, and specifically the EEOC. The text covers the topic well, and understanding this material can go a long way towards preventing your facing the consequences of real or implied discrimination in your career. I would like to cover some of the more subtle aspects of EEO law and policy. Some are intended to provide you with a different insight to such activities, and others are my observations and opinions, of which I'm sure not all will agree. But that's what makes for a good discussion. Obviously, discrimination is the commonality in the discussion. So, let me start by further explaining my statement in the introduction that discrimination has gotten a bad rap. One dictionary definition of discrimination is, quote, an act or instance of discriminating or of making a distinction. The power of making fine distinctions, end quote. Another definition includes, quote, the practice of unfairly treating a person or group of people differently from other people or groups of people, end quote. Discrimination has gotten a bad rap. Should we or an organization discriminate? Well, when you think about it, we discriminate every day. We choose one group over another. We choose one individual over others. We discriminate when we vote. We discriminate when we choose to donate to charities. We all discriminate all the time. Discrimination is the essence of good business. Being able to discriminate in who we hire, who we promote, who we pay and how much, and many other normal business practices is not only important, but expected and required. I expect my doctor to hire the best lab technicians, nurses, and specialists, regardless of their race, sex, national origin, etc. I expect my local police department to hire and promote the most effective police people, regardless of their race and sex, etc. And for years now, businesses have been whining about laws restricting their activities and not allowing them to hire the best. The laws do not forbid discrimination. They forbid discrimination for the wrong reasons. Organizations can still hire the best people and promote the most qualified. They merely have to demonstrate that the decision was made disregarding race, sex, national origin, and all of the other protected class factors. Organizations must merely prove that the decision was based on actual job criteria and not on the opinion of one manager or supervisor. Now, don't misunderstand. There are aspects of some laws of which I disagree, but these laws don't prevent managers and leaders from fulfilling their obligations to the organization. When confronted with such whining by managers, I always respond, you can do anything you want as long as you do the right thing in the right way. Failing to hire or promote someone merely because they are female or black or Latino or older or pregnant is not right. Read ethical, moral, and legal. It is not the right thing to do. Failing to hire those who are female or black or Latino or old because they are not qualified is the right thing to do, and that decision can be defended. Now, I think we can agree that discrimination is a necessary part of managing, leading, and decision making. But discrimination based on protected classes defined by law is wrong. But that is an oversimplification of the compliance challenges presented by many laws. What is discrimination? What constitutes discrimination? Because if I don't clearly know what it is or what acts are discriminatory, how can I prevent it? Let me illustrate this issue with the distinction between disparate impact and disparate treatment, which are discussed in the text. It's my assertion that disparate treatment is much easier to observe, diagnose, and treat and prevent than disparate impact. Disparate treatment is also easier to explain and define to other members of the organization than disparate impact. Disparate treatment normally is displayed when an individual or a small group of individuals are treated differently. They don't receive promotions, they have different hiring criteria applied, they are paid less, or their working conditions are not equal to some other disparity is apparent. In other words, an individual group is treated differently. As a manager, I can usually observe and diagnose that problem with very little difficulty. I can readily see it if I'm paying attention. Disparate impact is present when members of a protected category are substantially underrepresented as a result of employment decisions that work to their disadvantage. Or as the text puts it, quote, when an action has a disproportionate effect on a protected group regardless of the employer's intent, end quote. What is a disproportionate effect? There are two problems for management with this definition. First, it is often difficult for a manager to see underrepresentation in a protected class. What is adequate representation? Is proper representation of females 20% or 30% or 60% in the workplace? It's easy to see disparate impact if an organization has 10 supervisors and all of them are white males. In that case, all minorities are underrepresented. But what if an organization has 100 supervisors and 50% are female and 50% are males? Are females underrepresented? Well, the answer may be yes, if 80% of the employees are female, or if the answer may be no, if only 10% of the employees are female. So proper representation is defined by the number of individuals who should be in a category versus the number of individuals available. And the number available is often in dispute. I worked for a large corporation that was involved in a dispute with the EEOC over hiring practices in one of its manufacturing facilities. The facility was located in a rural community that was approximately 25 miles from the larger city. The minority population in the surrounding community was 10% of the total community. The company employed around 15% minorities in its facility. By all measures, minorities were not underrepresented. The EEOC claimed that the facility should have recruited from the larger city and not just within the surrounding community. When the minority population of the larger city was included in the hiring area, the minority population increased to over 20%, and the total population in the company was underrepresented against that criteria. So what was the normal recruiting area of that facility? The company and the EEOC obviously disagreed. From a practical standpoint, the minority population of the larger city was concentrated in an area about 35 to 40 miles from the facility. The facility paid competitively with the local community, but lower than the norm for the larger city. Unemployment was around 4%, which is really considered near full employment. Therefore, it was difficult to find qualified available employees and impossible to hire qualified employees who were willing to travel such a distance to work for less wages than they could obtain much closer to the city. Were minorities underrepresented? In my opinion, no. But the EEOC case went on for 10 years without resolution. Underrepresentation is often in the eyes of the beholder, while disparate treatment has a much clearer result. This is not a defense of discrimination, but it is a caution to those who practice management. Guard against both disparate treatment and disparate impact, but realize you may be engaging in disparate impact and not even be aware of the danger. Caution is in order. When a law is passed through Congress, think in terms of the Affordable Care Act, for example, the law actually outlines the intent of the law, but not the full detail. For example, I remember when the Americans with Disability Act was passed, there was great confusion as to what the law actually meant. No one knew specifically what was required to come into compliance with the law. The law was written by Congress. The law as written by Congress was too broad in general to spell out any operational specifics. What is a disability? Who is covered under the Act? What are the penalties for noncompliance? The questions went on, and no answers were forthcoming. Congress passes the law on to bureaucrats who promulgate regulations providing details, at least as many details as they can think of. Under the original law, obesity was not covered specifically. But was obesity a disability by definition? The bureaucrats ruled that obesity was not covered. Someone who was obviously obese disagreed with that and filed a lawsuit against a company somewhere. The courts ruled on that and other cases that obesity was a disability in those particular circumstances. The confusion begins when the courts ruled differently on the same general issues, such as obesity. Some courts ruled that obesity was covered, and others ruled that it wasn't. Still others ruled that it was covered in some instances, but not in others. Is it covered or not? Well, it depends on... As you can see, human resource management legal issues are not clear, and they're always up to interpretation by governmental regulators, bureaucrats, and the courts. And those rulings are observed by the bureaucrats who ultimately change the rules and the regulations to represent the court's rulings. First comes the law by Congress, then come the regulations by the bureaucrats, then come the rulings by the courts, and as in the ADA, then comes more laws by Congress, ADA Amendments Act, for example. Although laws may provide clarity for some who feel wronged, they provide mass confusion and great risk for those who try to comply with the laws on a daily basis. Such is our system, and noncompliance is not a solution. That said, complying with laws and regulations can be like chasing a moving and ever-changing target. This confusion begs the question, why do we have all of these regulations and laws anyway? Why do we have laws that protect minorities, females, pregnant females, people from other countries, older people, people of various religions, and disabled people, etc.? Simply, we have laws protecting them because many people and many organizations have actively discriminated against these groups in the past. Organizations can thank no one but themselves for having restrictive laws. And it is easy to blame these discriminatory practices on evil business people who care about nothing more than money and power. Those who hold that opinion are engaging in misconception to the same extent as organizations whining about the laws preventing them from meeting their obligations. You see, in my experience, most leaders and managers do not set out to openly discriminate against people in protected classes. Most leaders and managers are good, decent people who are trying to compete in a global marketplace and also maintain an ethical position in an ever-changing national culture. Their intent is to provide a successful organizational culture that can afford a positive contribution to customers, employees, and communities. Sometimes they make mistakes. Sometimes they don't recognize the right action or the wrong action. Sometimes they need objective guidance away from the business fray. And often when confronted by the concept that they may be inappropriately discriminating against a person or group, they are horrified at the thought. For example, I worked for an individual I'll call Bob. Bob was one of the finest leaders I have ever met and one of the finest people I've ever met. The organization was temporarily without a purchasing manager, and a young female buyer, I'll call Mary, had accepted most of the managerial roles. She was dealing on the new level with vendors, legal issues, and other managers, etc., and she performed very credibly. The purchasing manager was scheduled to return to work, but in the meantime, she ensured that all aspects of the purchasing operation remained afloat. The department pay structure allowed for a high-level Buyer 1 position and a lower, less experienced required Buyer 2 position. The young lady was in the Buyer 2 position. I approached Bob and proposed that we move Mary to a Buyer 1 position as a promotion with a pay increase. Bob argued that she still didn't have enough experience and acknowledged that her performance was exemplary, but she just wasn't ready. We argued and discussed, mostly argued, and I left Bob's office declaring that I believed he was discriminating against her because she was a female, and if she was a male, he would have no problem with the promotion. His anger at that comment was barely under control. He declared unequivocally that he did not discriminate, and I was out of line for implying such. About an hour later, Bob came into my office and said that my statement had bothered him greatly. He said he had been thinking about it and agreed that he was discriminating because Mary was a female, and in his mind he had set up different criteria for males and females. He didn't even realize he was doing it. He was embarrassed and disappointed in himself. He agreed that of course the promotion was in order and we should announce it as soon as possible. Now, I was not embarrassed or disappointed in him. I was overjoyed that my previous assessment of his goodness was reinforced. That is why I considered him to be one of the finest leaders I've ever encountered. He was able to analyze himself, recognize his weakness and flaws, correct them, and do the right thing. His apparent goodness was his greatest strength. He didn't realize that in that one situation he was discriminating. Don't you sometimes do inappropriate things and don't realize they are inappropriate until someone else points it out or until you can look at it later? It doesn't make you evil, it makes you human. I know there's discrimination in organizations, but I also believe the incidents of discrimination are becoming less. One reason is more awareness, and another reason is the risk of consequences, both monetary and social, for discriminatory practices. A third reason, I believe, is that organizations are full of good, decent people who want to do the right thing. It's one thing to define what is right and legal. It's another thing to get everyone to act in a correct and legal fashion in a large or even a small organization. Perhaps the best method of preventing such behavior is regular training. Such training should include definition of terms. What laws apply? What is discrimination? What are protected classes? What type of behavior is considered violations of the law? The first goal of training is to give managers and employees information and knowledge. The second goal is to make them aware and vigilant. Managers and employees should watch out for each other. I've had managers come to me and express concern that an action or comment from a colleague could be interpreted as discriminatory. Upon investigating, I often found it to be an innocent statement. But an innocent statement or action that could have been misinterpreted. Training raises awareness and also reinforces the importance of compliance. I generally conducted such training sessions on a regular basis, often annually, and specific training sessions if I believe particular recruitment project or employment event warranted special attention. Remember, managers don't want to run afoul of the law. It is generally done unintentionally. Sometimes you don't intend to speed, but you do so through inattention. However, if you get caught, it really doesn't matter. You still pay the consequences. Let me end this discussion with a thought that you may find controversial. There are a lot of laws and regulations to comply with. Some are big and right, such as discrimination laws we have been discussing. Some are vague and obscure and have a limited range of impact. I used to tell managers that they can be sure that someone somewhere is breaking a law of some kind, doing something. It is particularly true in large organizations. But they are breaking the law either because they are unaware of the law or because they're in one of the vague areas that is open to interpretation. Rarely do people break the law by disregarding it in organizations. I believe that most legal issues arise in those vague areas that are subject to multiple interpretation. How do we reduce our compliance risk in those situations? Seek other eyes. Seek other interpretation. Seek other viewpoints. In this case, seek legal advice. This is not a commercial for attorneys, but managers can't be experts in all areas. Organizations seek advice when faced with vexing technical problems and issues. Organizations seek advice when analyzing the marketplace. Organizations seek advice when reviewing taxes or other financial problems. Seek professional advice when dealing with selection and hiring or compensation issues. You can know a lot, but you can't know everything. And unfortunately, the legal climate renders all of us susceptible to what we don't know. Good, knowledgeable professional advice is always cheaper than bad consequences. So, what tasks must be done in the organization? How do we group those tasks together to form jobs? Sounds exciting, doesn't it? Well, control your excitement for one more week, because next week we'll discuss strategic job analysis and competency modeling.